Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the K-1 visa process, and quite honestly, this is almost an opinion video, but man, the level of redundancy in the K-1 visa process is just getting ridiculous at this point. I really think comprehensive immigration reform is absolutely necessary to get the immigration system back on track, but man, the redundancy is just crazy. I mean, stuff we're dealing with now, for example, U.S. Embassy here in Bangkok is now asking for folks to show their original divorce decrees associated with petitioners' prior divorce in a K-1 visa adjudication. And why this is required is absolutely baffling to me because Department of Homeland Security is in charge of that type of adjudication. I've never seen the embassy out here or any embassy in this region ask for proof of not just proof of divorce in the form of a copy, but an actual original or originally certified divorce decree. And this is not the easiest thing in the world to get. And I really do not understand why it's being requested. And that's where it gets into the redundancy because Department of Homeland Security, specifically USCIS, is tasked with making those adjudications. They get into issues associated with petitioners' marital status. That is their mandate. Department of State doesn't have that mandate. And yes, immigration officers have the discretion to look at the whole case. I get all of that. The doctrine of consular absolutism or non-reviewability, we all understand that. And there is an element of that, although not as big an element of that in the immigration unit, in the immigrant visa unit, I should say. There's not as big an element of that as it is in the non-immigrant visa unit, but it's still there. Consular officers need to make factual determinations. I get that. But in the case of petitioner divorce decrees, that's already been adjudicated by USCIS. Just like a billion other things have already been dealt with by Department of Homeland Security that then you refile again when you're dealing with the back end of the process. It's very redundant. I think it's pretty much high time. They kind of talked about this when Tillerson was Secretary of State, if somehow, and I know that there's sort of bureaucratic wars that happen when they discuss these things, but they were talking about sort of amalgamating both DHS or DOS and kind of putting them together. That really didn't go anywhere. I think the only way to do this is under comprehensive immigration reform through Congress and basically delineating, in my opinion, family-based visas, especially family-based visas for American citizens, should be entirely adjudicated abroad if they're coming in from abroad, and then just kind of either take out the Department of Homeland Security function or take out the DOS redundancy. But whatever you do, I mean, you're basically doing everything twice in the process at this point, and they're asking for stuff now in different parts of the process where they really don't have a mandate to do that. Again, I'm not being critical of Department of State. They may have their reasons for this. I don't know why. Maybe an anti-fraud sort of prevention thing. But long story short, it is redundant.